Good afternoon and welcome to the Federal Bar Association Chicago Chapter's program, the Equal Rights Amendment, Past, Present, and Future. I'm Kim Sue Nagel, President-elect of the Chicago Chapter. We've got a great and timely presentation for you today. Before we get started, I'll take this moment to encourage you to become a member of the FBA's Chicago Chapter. Membership in the FBA has many benefits. Our chapter is distinguished by the high level of involvement of the federal bench. Membership in the FBA is a great way to get better acquainted with our local federal judges. We're proud to host the Northern District's annual State of the Court address presented by our Chief Judge. Today's fantastic program is typical of the high quality CLE that the chapter regularly offers. And our programs recently included the Employment Law Seminar, Settlement Assistance Pro Bono Training Program, and an update from Chief Judge Paul Meyer on how the Northern District of Illinois is coping with the COVID-19 crisis. In a typical year, we host popular informal lunches with federal judges in their chambers, as well as a number of free events for our members, including the Moran Membership Appreciation Event, our holiday party, and our ethics program, offering many hours of free professional responsibility CLE. In this highly atypical year, our chapter membership has also provided a unique and excellent opportunity for people to engage in interesting legal programs and to network during a time of limited social contact. So I encourage you to consider joining the FBA's Chicago chapter. If you're interested, please see the chat for my email as well as our website. At 1 p.m., I will share the CLE code for you for those purposes. And thank you. Now we're honored to present the Catherine Smith Matkoff Awards. The Chicago chapter bestows this award on an attorney or judge whose lifetime commitment to excellence and accuracy in defining, illuminating, and informing the public on critical issues to American society. And this award is given in the name of Chicago chapter past president, Catherine Smith Matkoff, who at a young age passed away from cancer shortly after completing her tenure as chapter president. And in recognition of Catherine's commitment to improving conditions for children, the aged, and minorities, our chapter president, Morgan Hurst, and former chapter president, Paul Freeling, as nominators, will appropriately present these awards to our distinguished winners. Morgan?
Thank you, Judge Nagel, and good afternoon, everybody. Welcome to the program. And I think it's kind of particularly fitting today that we're kicking off this program during Women's History Month concerning the Equal Rights Amendment by honoring these two remarkable women, Sarah Galloon and Mary Mcmacarthy, who have done so much for the disadvantaged by presenting them this award in the name of another remarkable woman, Catherine Smith Matkoff. I have the honor of introducing Sarah Galloon. Sarah is a passionate advocate for parents, caregivers, and children. In her work, first with the Family Defense Center and now with Rescind Justice, Sarah has committed herself to correcting mistakes made by the Illinois Department of Children and Family Services and helping families thrive. In her current role, Sarah serves as the co-director of extended services at Rescind Justice, which is a not-for-profit legal services organization dedicated to empowering individuals and families impacted by gender-based violence and the child welfare system to achieve safety and stability through holistic legal advocacy and system reform. During the course of her work, Sarah has represented and advised hundreds of parents and caregivers in all aspects of child welfare investigations and litigation. Through federal civil rights and class action litigation, Sarah's played a lead role in obtaining and enforcing significant improvements to rules, policies, and practices of the Illinois Department of Children and Family Services, particularly relating to safety plans, mental health practices, families experiencing domestic violence, and previously overbroad categories of alleged neglect, known as Allegation 74. I first came into contact with Sarah during her time as the Director of Legal Services for the Family Defense Center, where she led the pro bono program and was in charge of recruiting lawyers in private practice to work with the Family Defense Center on individual cases where parents or caregivers had been targeted, investigated, or indicated by the Illinois Department of Children and Family Services. This was not an obvious ask for Sarah. She had to convince law firms to commit their limited time and their pro bono resources to defending individuals who had been accused of neglecting or abusing children in their care. And for these law firms to publicly ally themselves with against Illinois DCFS, Sarah to show them that decisions being challenged were unjust, capricious, and detrimental to families. And as with everything else Sarah does, she was utterly persuasive in her pitch to these firms, including my own. She not only convinced us to take on and to overwhelmingly win individual cases for people who were wrongfully indicated for neglect, but she also coordinated federal civil rights litigation and class action litigation to improve agency policies for all families. These individual cases are incredibly meaningful and frequently involve advocating for single parents, mothers, immigrants, and people of color who are wrongfully targeted by DCFS for making parenting decisions that would not have been questioned in white or two-parent families. In reflecting on the values of the Macoff Award and what that award was created to recognize, it is difficult to imagine a more appropriate or deserving candidate than Sarah. For so many individuals, family is the most important thing in their lives, and yet for so many non-traditional families, the institutions designed to protect these families have failed. Although Sarah's tireless advocacy in giving a voice to these underrepresented families, to single mothers, survivors of domestic violence, immigrant households, and others, is offered without any expectation of recognition, the work nevertheless deserves that recognition. And I'm so proud today that we can recognize that work and award Sarah with the 2021 Catherine Smith Mcmacarthy Award. Sarah, congratulations.
Thank you so much, Morgan, and thank you so much for those kind words. I was truly surprised and humbled to receive this award, especially alongside someone with as illustrious of a legal career as Mary Mcmacarthy has had. So I just thank the entire committee and legal community for this recognition. I want to thank my family for their years of support of my career, the wonderful clients that I've had the privilege of representing over the years, and my great colleagues at Ascend Justice. I'm very fortunate to work there and be able to do this work. Thank you so much.
Congratulations, Sarah. And with that, I want to turn it over to one of our past presidents and the current chair of our awards committee, Paul Freeling, to introduce Mary Mcmacarthy.
Thank you, Morgan. It's my privilege to introduce Mary Mcmacarthy, another of the winners of the Catherine Smith Mcmacarthy Award. Mary Meg is the executive director of the Heartland Alliance's National Immigrant Justice Center, and I will refer to that as NIJC. NIJC is headquartered in Chicago, has offices in Washington, D.C. and elsewhere, and it is at the center of the United States immigration firestorm, which we read about and hear about, unfortunately, in some ways, unfortunately, every day. NIJC represents, among others, persons, refugees who, some of whom are living in the United States, such as dreamers. As you sure know, dreamers are young people who came to the United States with their parents, and the United States is the only country they've known, and now our country is seeking to deport them. NIJC also represents many refugees who are at our border, and I have a hunch Mary Meg may tell you a little bit about some of those refugees. Some of the most heartbreaking stories are these refugees who have faced terrorism of two kinds in their home country, oftentimes Central America. The two kinds of terrorism to which I refer are nature's terrorism, in the form of earthquakes and floods and hurricanes and various natural disasters that have cost these individuals their shelter and their electricity and their water, and they have somehow or other made it to our border to try to get some protection. These refugees also face human terror in the form of domestic abuse, marauding criminals, militia who come into their villages, kill, rape, loot, destroy the villages. And again, the refugees have come north to try to get some protection in the United States. Mary Meg has a staff of approximately 100 employees at NIJC, and she has recruited an army of about 1,500 volunteers all across the country, lawyers and paralegals who assist in this effort for representing the refugees. I know a little bit about that. I was privileged when I was practicing law to be one of the volunteers who assisted NIJC. I think I will leave it at that, except to say that Mary Meg is the face of NIJC. She is such an expert on immigration law and practices in the United States that she's the person who frequently Congress calls upon to testify and who the media seeks interviews with to explain what is going on in the immigration world. It is truly my pleasure to introduce my friend, Mary Mcmacarthy.
Thank you. Thank you very much, Paul, for those very generous and kind words. And I have to share this award with my colleagues at the National Immigrant Justice Center, who really are the force behind what NIJC is today. I am honored and humbled to receive the Kate Metcalf Award, and especially along with Sarah, who has done some amazing work on behalf of families that are so critical. Kate was an extraordinary leader in the legal field with this amazing commitment to pro bono services to women and children and minorities. And I'm grateful to Paul and to Fern and to Peggy McCormick, who've all been part of my experience with the Federal Bar Association. As the executive director of NIJC, I have seen the extraordinary pain and tragedy facing truly the most vulnerable in our world, immigrant women and girls. We provide legal services to these individuals. And this award is really timely today, given the attacks and the murders of the Asian American women in Atlanta. I can't help but think that someone like Kate would agree that now more than ever, we need to stand by our brothers and sisters in the Asian community and fight for justice for all, and particularly women who are disproportionately impacted. People and families around the world are fleeing violence, sexual assault, and abuse after being targeted because of their race or their ethnicity or gender or their age. And they seek protection in the US, a legal right. Yet without an attorney, they face serious obstacles to even begin to access those protections. What we are seeing on the border today is not a crisis. It is a challenge and an opportunity for us as lawyers to ensure that we treat children and mothers humanely and that they have access to counsel. Immigrants with legal counsel are 5 times, again, 5 times more likely to prevail in their case. Kate provided pro bono services to women and children. Today, we are all called to follow in Kate's footsteps and provide pro bono services to the most vulnerable in our communities. If we don't do it, who will? Thank you for this award, and more importantly, thank you for your commitment to justice. Like Kate, as lawyers, we can all make a difference in the world. Thank you.
Thank you, and congratulations to these inspiring women in your call to action. Thank you so much. We proudly present the Equal Rights Amendment, past, present, and future. It's my honor to introduce our distinguished panel of experts, on-the-ground activists, and legal scholars who will discuss the efforts to ratify the ERA in Illinois and other states, litigation concerning ratification, and the future of this important amendment. You'll find supporting materials in the webinar box, and we'll have an opportunity for Q&A at 1 p.m. Please type your questions in that question box. Linda Coberly is the Chicago Managing Partner of Winston & Strawn. Linda leads the firm's appellate and critical motions practice. She handles appeals in the Seventh Circuit, as well as in federal and state courts of appeals around the country. Linda played a role in the ERA ratification effort in Illinois and is now the chair of the ERA's coalition's legal task force. Linda also clerked for Justice Stephen Breyer of the Supreme Court and for Judge Douglas H. Ginsburg on the D.C. Circuit. Linda attended Princeton and earned her JD from the University of Michigan Law School. Welcome, Linda. We are also proud to present Kathy Hunt Muse. Kathy serves as the Deputy Chief of the Public Interest Division in the Office of the Illinois Attorney General. Prior to working for the Attorney General, Kathy worked as Special Litigation Counsel at the ACLU of Illinois. Kathy also worked for years in private practice where she focused on complex commercial litigation and had an active pro bono docket focused on civil rights litigation. Kathy received her BA from the University of Pennsylvania, summa cum laude, and her JD from Yale Law School. Kathy also served as a law clerk to the Honorable Anita B. Brody in the Eastern District of Pennsylvania. Welcome, Kathy. We also are proud to present Kate Kelly. Kate is a passionate activist and vocal women's rights champion in the U.S. and around the world. She's a nationally known advocate for the ratification of the Equal Rights Amendment and host of the podcast, Ordinary Equality. Kate has a forthcoming book next spring called Ordinary Equality about the history of the women who have shaped the U.S. Constitution. She earned her JD from American University Washington College of Law, the only law school in the world founded by and for women. Kate graduated cum laude in 2012. We will start our panel presentation today with Kate. Thank you and welcome all of you.
Hi, everyone. Very excited to be here. The Equal Rights Amendment is one of my favorite topics and one of the most important legal issues of our day. And so I'm just thrilled to be here and thrilled that so many folks are interested in changing our Constitution. So I want to talk about the history of the Equal Rights Amendment, and we can get into this more as we go on and if folks have specific questions. But one of the myths about the Equal Rights Amendment is that it's a white women's issue and that only straight white women, particularly older women, care about it. This is not true now and has never been true. The Equal Rights Amendment was written by a group of 4 women, sort of in concert following the ratification of the 19th Amendment. So the 19th Amendment really galvanized women across the country. They worked together, they formed groups, they organized, they door knocked, they wrote letters, they testified in Congress, and they gained all these skills. And all along, as they were working to secure the 19th Amendment and the constitutional right to vote, they were planning for the future. They were talking about what it could look like. And in fact, even in the original 1848 Seneca Falls Convention, the first women's rights convention, there was a question about whether or not the vote would even be on their platform, what they called their Declaration of Sentiments. One of the people that supported the vote was Frederick Douglass, from the very earliest stages, famous, formerly enslaved abolitionist. So Frederick Douglass was at the first Women's Rights Convention in Seneca Falls and advocated for the women to include the vote on the Declaration of Sentiments, even though it was very, very radical and far out at the time. Throughout the fight for suffrage, like I said, women were gathering, women were thinking about the future. As soon as the 19th Amendment was ratified in 1920, a group of women got together in 1921 and wrote the next amendment. They're like, we have the vote, now we're going to use the vote to get people in office who will give us rights, who will expand our rights. One of those women was Alice Paul. Alice Paul was a suffragist and really helped get the 19th Amendment over the finish line with some really radical tactics, including picketing the White House, planning a suffrage parade, and in opposition to the inaugural parade, so sort of steal the thunder of Wilson. They did a lot of really radical tactics, ended up going to jail, being force-fed. These women were very serious about getting the right to vote. Once they did, they pivoted and wrote the Equal Rights Amendment. So the first drafting of the Equal Rights Amendment was in 1921. Were these women straight, white, housewives? No, they were not. Most of the women who rose to the highest ranks in the suffrage movement and were the real leaders were actually queer women. Why? First of all, they didn't have children to take care of, which was the burden. Also, women at the time, if they got married, would become the property of their husbands, as would everything they owned and their children. And so marrying was actually a real liability. So many of the women, including Alice Paul, never married. It's unclear whether or not Alice Paul had romantic relationships with other women, although I'm queer and I'm gonna go ahead and say that she did. She had a very close relationship with Lucy Burns that some consider to be romantic. Crystal Eastman was another original author of the Equal Rights Amendment. Crystal Eastman is the original person who conceptualized and created the ACLU. This is little known. In fact, the idea for the ACLU was stolen from Crystal by the man who then went on to lead the ACLU when she was on bed rest from a pregnancy in New Jersey. So they were starting the ACLU, it was growing out of another project. She was on bed rest in New Jersey, like furiously, like trying to write letters and trying to be involved, and the idea really, and the leadership of the ACLU was stolen from Crystal Eastman. So I could talk for a long time about that, but these women were lawyers. Alice Paul graduated from American University Washington College of Law, the same school that I graduated from, which was founded by suffragists. Part of the reason she went to law school is to learn how to write and advocate for another amendment to the Constitution. It was originally introduced in 1923. Women of color were also very active in the fight for the Equal Rights Amendment. We know that Ida B. Wells, in that parade that I talked about, Alice Paul was a pragmatist and in also many ways a racist. And I'm just gonna say it that way because that is true. And people are nuanced and we need to tell the truth. So in this suffrage parade, Alice Paul dictated, and because she thought it was in her best interest politically, that women of color, particularly Black women, march in a segregated unit in the back of the parade. Ida B. Wells, however, said, I'm not doing that, had a confrontation with Alice Paul, and she marched with her unit. Her Illinois unit of suffragists marching in the front of the parade. And so women of color were very active in the efforts to change our Constitution. Mary Church Terrell, another suffragist, Mary Church Terrell, once the 19th Amendment was ratified, did that mean all women could vote? No. There were many barriers, procedural and otherwise, to specifically women of color voting in this country. So Mary Church Terrell went to the leaders of the National Woman's Party, which formed after the ratification of the 19th Amendment, and said, okay, we got the constitutional right to vote, but that doesn't mean we can all vote. And so we need to continue that work. They, however, decided to turn no. Now we're going to turn to the Equal Rights Amendment. Despite their conflicts, Mary Church Terrell supported the Equal Rights Amendment. In fact, she testified in Congress in the 1940s in support of the Equal Rights Amendment, as did many of these other women, including but not limited to Polly Murray. Polly Murray, now posthumously considered to be a transgender woman, a transgender person who advocated for women's rights, including was one of the original founders of the National Organization for Women, testified in support of the Equal Rights Amendment. Barbara Jordan, the first Black woman from the South, elected to Congress. She also we now know, again posthumously, was a lesbian. And so Barbara Jordan was a big proponent of the Equal Rights Amendment. Patsy Mink, the first woman of color to ever enter Congress from Hawaii. Patsy Mink was a huge proponent of the Equal Rights Amendment. So all along, these stories have been lost, but all along, queer people and women of color have been advocating for the Equal Rights Amendment. That continues to this day. So all of the places where the Equal Rights Amendment has currently been ratified, including starting in Nevada with Senator Pat Spearman, a queer Black preacher who got it across the finish line in 2017 in Nevada. Then, of course, you all know the story better in Illinois. Many women of color fighting for, including the current lieutenant governor, fighting for ratification of the ERA. And also very, very prominently in Virginia, the women of color were pushing for ratification in both chambers, in the Senate and the House of Delegates. In Virginia, we had Jennifer Carroll Foy. In the House of Delegates, we had Jennifer McClellan in the Senate. And so all these women of color in all these places have been and are continuing to fight for the Equal Rights Amendment. So it was first introduced in 1923. The language was changed, as we'll see. And then in 1972, it was passed. It was passed by a vast, wide majority. It was wildly popular. It was on the platform of both political parties. In the House yesterday, you saw that the vote on the Equal Rights Amendment was very close. It really broke down on party lines. There were only 4 Republicans that voted for the Equal Rights Amendment. In 1972, that was not the case. It passed, I think there were only 20 folks who voted against the Equal Rights Amendment in 1972. So it was wildly popular, immediately ratified. 30 minutes later, on the same day that it passed in Congress, it was ratified in Hawaii, in large part due to the leadership of Patsy Mink. And so we see the Equal Rights Amendment, it was a foregone conclusion. Folks thought that it would be ratified and we would be well on our way. Well, what happened? The Equal Rights Amendment, unfortunately, there was what some refer to as an arbitrary time limit attached to the Equal Rights Amendment in the proposing clause. So when it was passed in 1972, the 7-year limit was attached to it. That original author of the Equal Rights Amendment, Alice Paul, was still alive and was still advocating for the Equal Rights Amendment in the 1970s. When it passed with the deadline attached in 1972, activists went to find Alice Paul. She was at the National Women's Party headquarters, which is a few blocks away from the Capitol, and they found her weeping. She was weeping on her desk, and she was distraught. Why was she distraught? She said, the time limit is a poison pill. So in that way, her prophetic vision and leadership also predicted that the Equal Rights Amendment, the efforts to ratify the Equal Rights Amendment would be killed by the time limit. That prophetic vision did come true. And in 1979, there were 3 states short of ratification of that 38 state requirement. In 1978, before the ratification expired, Congress was scrambling. What do? And they voted to move the deadline. They moved the deadline from 1979 3 additional years to 1982. And we can talk more about why that was and why didn't they just eliminate the deadline. Short version of that story is they knew that that was not enough time to change the state senates in the states that needed to ratify. And so they could extend the deadline because there were hundreds of thousands of people marching, and this was a huge political issue. They could extend the deadline without actually making a difference and without putting the Equal Rights Amendment over the finish line. And that's where we are today, 3 states short, and we now have those 3 states, Nevada, Illinois, and of course, Virginia, the 38th and final state needed to ratify the Equal Rights Amendment. And I think, again, it's just important to keep in mind who has been fighting for this amendment, and we'll talk later on about why that's important and who it will cover. But women of color, people on the margins have been fighting for this amendment since its very creation.
So I'm going to jump in and talk about the recent ratification efforts that Kate mentioned. And so, for many of us, and one of the things I'm most excited for about this panel is that I'm the oldest one on it. And, I have, since I've been working on the ERA, I have spent a lot of time with feminists who have been working on the ERA for decades. And, but I'm happy to say that there are feminists of all generations, including my own daughters who are working on the ERA and advocating for it today. So let's talk a little bit about what happened after the 1970s. And the answer is a lot, although people didn't talk about it very much in a lot of public sphere. Many of us probably thought that the ERA died. You know, when I first got involved in ERA advocacy, which was just a couple of years ago, I asked a question at a program, how many of you think the ERA is actually already in the Constitution? And a lot of people thought so, including lawyers, because they remember it as a thing that happened in the 1970s, and that's kind of all they know. Well, after the extension passed that Kate mentioned, after 1982, there were the movements to have the ERA become part of the Constitution kind of went underground a bit. And there were proposals every single year in Congress to create a new ERA, to start the process over, on the theory that the time limit on ratification had expired, and so you needed to start over. In the 1990s, something changed to kind of change the subject, and that was the ratification of the 27th Amendment. Our 27th Amendment covers congressional pay, and it is known sometimes as the Madison Amendment because it was proposed by James Madison. Yes, that James Madison, and it took 203 years to ratify. And there had been a sense before that amendment became part of the Constitution that really you needed this all to happen kind of at the same time or within a generally reasonable period of time. But when the Madison Amendment was finally ratified, and I'll tell a quick story about that. It was actually the topic of a school paper that a gentleman wrote, and he thought, well, maybe we could actually get this thing passed. And he did not get a very good grade on that paper, but it did end up creating a movement to complete the ratification of the Congressional Pay Amendment, and it was finally ratified in the 1990s and became recognized as part of the Constitution. And that gave the ERA advocates a different idea. What if we just complete the ratification that started in the 1970s? Well, there were efforts to do that in many jurisdictions, and it finally bore fruit in 2017 with the ratification by the state of Nevada. And the woman you see pictured here is, she is truly a force. She is a member of the clergy. She is a military veteran. She is a member of the LGBTQ community. She is a Black woman, and she is an incredibly forceful speaker. And as a state senator in Nevada, she drove forward the effort to ratify the Equal Rights Amendment in 2017. This took a lot of people by surprise, people who didn't really realize that the ERA fight was not over. And it was actually the ratification by Nevada that got my law firm involved. The chairman of our firm, Tom Fitzgerald, heard a story on NPR about the ratification in Nevada and called me to his office and said, we need to get involved in this. We need to do something about it. Did you know that Illinois still hasn't ratified? And so we got involved. We put together, we began to pull together activists who had been working for many years on these issues. We kind of joined along with their fight. And it was a really gratifying thing for all the advocates, including us at the firm who were working on it, to watch Illinois finally ratify the ERA in May 2018. In the center of your screen, you see our current Lieutenant Governor, Juliana Stratton, who spoke very passionately in favor of the ERA from the floor of the legislature. You also see Lou Lang and Republican Representative Steve Anderson, who is a pro-life Republican and has been a very active supporter of the ERA, including now as a board member of the National ERA Coalition. And you will frequently see him speaking out in favor of ratification. And then finally, the 38th state, the state of Virginia, led, as Kate noted, by Jennifer McClellan and Delegate Jennifer Carroll Foy, both of whom are running for governor now. And they, again, joined forces with people who have been advocating for the ERA for many years to finally bring Virginia over the finish line. And so this is where we sit today, with March 2017, Nevada, Illinois in May 2018, and Virginia in January 2020. So that brings us to today and to some pretty interesting legal issues. And I'm going to turn things over to Kathy to take us through them.
Thank you, Linda, and thank you for having me. Just a quick disclaimer that I'm going to be speaking today on behalf of myself, and you should not construe anything I say as the opinion or a statement from the Office of the Attorney General. In particular, I'm going to describe legal arguments related to the litigation for the benefit of a CLE discussion, and I want to make clear that those are not statements that should be attributed to our office. So let's dig into what all the lawyers presumably came here for, which is the legal arguments. What's the big argument about? So first, if you open up your Constitution, you will find Article 5. That is what governs how the federal Constitution is amended. It creates two basic ways for amendments to happen, or modes. Both ways only involve Congress and state legislatures. Neither of them require anything from the executive branch and the judiciary for the amendment to be adopted and added. So one of those modes is not applicable here, and that's the convention option. So here, as Kate has described, Congress proposed an amendment. As you'll see from the text on the screen here, it requires 2/3 of both houses to propose the amendment. And then it says that the amendment becomes valid and part of the Constitution when it has been ratified by 3/4 of state legislatures. There's a ... there, but I can tell you, you can look through Article 5, you will not find another thing that needs to happen. So from the last map slide, you would think, here we are, we've got this amendment clearly because the requirements of Article 5 have been fully met. So I could end the CLE here, but for the sake of describing the various legal arguments, I will lay out some of the legal arguments that have been made to justify ignoring what we think is the full constitutional process being complete. So let's dig into the time limit that Kate said has been described as a poison pill, because I think that that's really where the focus is. And certainly if you see news articles, they'll often describe the last 3 ratifications as happening too late. So as you saw from the text of Article 5, it doesn't say anything about a time limit for how quickly states have to act. At the time of the Constitution, I think things move more quickly. And but as Linda mentioned, or Kate, excuse me, I forget which of you, that the most recent amendment to our Constitution, the 27th Amendment, took over 200 years. So there's clearly some implicit timeline in Article 5 that applies. So here, the time limit that was put in is in the preamble, this red outline. It is not in the article, in the actual text of the amendment. So in other words, there's nothing in the text of the amendment itself that has the time limit. So if you look at your Constitution, you will look at the 18th, 20th, 21st, and 22nd Amendments, and you will see the 7-year languages in the text of the amendment. So the states that have been leading the litigation on this, which I will get to later, have been arguing that at a constitutional level, there's no time limit for states to act. 3/4 have ratified, it's done. If you compare the language in this preamble, it looks suspiciously like Article 5, except there's a new phrase in there that they've added about the 7 years. So that seems to be adding a new thing to the constitutional balance that's created in Article 5 between the relationship between Congress and the states. You know, Congress itself took 50 years to come up with the Equal Rights Amendment. So there are plenty of reasons why you might want to give states a little bit more time. One piece of it is that states get to decide themselves how they vote on an amendment to the federal Constitution. So in a lot of states, it might be in the state constitution, but it differs by state. So some states, for example, might have a provision that in order for the state legislature to vote to approve something to be added to the federal constitution, 2 different legislatures have to vote, and there has to be an election in between. And that's a way to make sure that the voters' wishes are incorporated. But that puts in a lot of time delay, and just makes this harder. But the second point about the preamble is, if any lawyers in the room have argued about a contract before, you know the dangers of putting a material term in a preamble. So I think that also highlights a novel constitutional question that hasn't ever been posed by another amendment before. Can there be a time limit at all? And if so, can you put it in this preamble? And that's not just a sort of gotcha contractual argument. Here, it actually has a very different legal meaning, what's in the article and what's above. As Congress itself has recognized when they voted to change that deadline. They didn't vote to change anything below the word article on your screen, and they couldn't have. So it's clear that there's a different legal significance to what's above and below that article, and if there's the ability for Congress to set a time limit at all, which we question, can they do it in this way? And neither of those have been answered before in this particular way. So I think that's where the most serious disputes are really residing. But I think that I'll also mention that another argument that has been made, not to success before, is that states can rescind their ratifications. So again, if you think back to the Article 5 slide, it didn't say anything about rescissions. It said when they ratify. So ratification is a one-way thing. We've never before allowed states to, sort of take back their ratifications in this country for prior amendments. And, when that has been sort of attempted in some way, like with the 14th Amendment, all 3 branches of the federal government treated the amendment as fully ratified. And today we're sitting here with those amendments in our pocket constitutions. I think you can also just imagine how chaotic it would be to not have a sense of what's in our federal constitution because state legislatures were switching parties and changing the mind from the last party and going back and forth. It would be hard to figure out a moment in time when all 38 are constantly doing things. And again, to sort of a state law procedural point, like I pointed out, that there's state law or state constitutions that govern how each state decides to ratify a federal amendment. I'm not personally aware, or I can't recall here for sure that there's any process for states to rescind their ratifications. There are processes for states to ratify. So I think that kind of just would open up another whole can of worms. If you have a very clear process for this is how the state ratifies, the state legislature votes, an election happens, the state legislature votes again, and then they can send the certification papers to DC saying we've ratified this. What's the process for when a state can say we take it back? There isn't a process, and that's sort of, I think, kind of underscores why this is a manufactured concept. And maybe something that I think people have even historically done, if we can see evidence of this, that even the folks who were maybe voting for rescission at times maybe understood it wasn't something they could do, but they maybe said they were doing it for the political benefit at the time. There's one more technical aspect that I think I would like to point out to kind of explain the current litigation, and that is the statute you see on your screen here. So if we say, okay, well, all of the constitutional requirements have been met, why aren't we all calling it the 28th Amendment? This statute creates a ministerial duty for the federal archivist to review the certification papers that the states send in and then publish it. That, I think, gives you context for why, on the next slide, there's been 3 lawsuits filed against the archivist. So first, three of what I'll call the anti-ERA states sued the archivist. Before January, before that final vote for that 38th legislature, before Virginia voted, they knew that Virginia was likely to do this. They knew we were about to hit 38 and this was going to become part of the Constitution. So they filed a lawsuit against the archivist because they couldn't sue the Virginia legislature and say, archivist, we want an injunction so the archivist can't publish the amendment. And at the time, the Trump administration was still in power, and the Department of Justice is who represents the archivist in court. And the archivist publicly announced around the filing of this suit that he would rely on the advice that he was getting from the Trump administration's Office of Legal Counsel and not publish the amendment unless told to do so by the court. So that case went away. As every good lawyer knows, you need a case or controversy. You can't continue a lawsuit against an archivist asking for an injunction to stop him from doing something that he's now publicly said he has no intention of doing. So that case went away. In January, again, 2020, again, before the final Virginia vote happened, when it was still 37 states, but again, in anticipation that Virginia was poised to become the 38th state, a pro-ERA group and some women filed suit against the archivist. Unfortunately, the district court in that case ruled that the plaintiffs don't have standing. You'll recall from, I think, an earlier slide about the text of the Equal Rights Amendment that there's a 2-year delay built into the amendment itself in terms of when it becomes effective. So claims by individual women based on the ERA were not yet ripe, and the court also found that the organization had not developed organizational standing. So that case was dismissed. It is on appeal, but the decision was limited to standing and didn't go into the merits about the overall status of the Equal Rights Amendment's ratification and adoption. So that leads us to our third lawsuit, where Virginia, I believe it was January 20th, was when the state legislature voted to ratify the ERA. They sent their certification papers to the archivist, just as Nevada and Illinois already had sent them in, and the archivist did not act, did not fulfill the duties under the statute that I showed you. And meanwhile, we had this public statement out there where he'd already said that he would be relying on the advice from the Office of Legal Counsel to not certify and to not publish the amendment. The states of Virginia, Illinois, and Nevada filed suit against the archivist and asked for a writ of mandamus, asking the court to just compel the archivist to publish the amendment, comply with its duties under the statute, and recognize the validity of the ratifications that these three states had done. So the states from the Alabama litigation intervened in our suit on the side of the archivist. So that suit is still pending. I'm lead counsel for Illinois in that lawsuit. In that lawsuit, we briefed all of the legal questions we've touched on today and received an overwhelming amount of support from really well-written amicus briefs and from business groups, from advocacy groups. Very well done. On March 5th, the court in our case issued an opinion on 2 grounds. First, he found that the states didn't have standing because we weren't injured by the archivist, because what the archivist does doesn't have an effect. But then he also went on to find that the congressional time limit was valid, and so therefore our ratifications were too late. So we are currently in the window of time to decide how we're going to push back on those decisions, which we believe both of those are wrong. And I should mention that my boss here, the Illinois Attorney General, and one of the 3 Attorney Generals leading the legal fight is pictured here and is continuing to consider you know, what's the best way to push this legal fight forward. So you know, even believing that the decision is wrong, I think that one thing that court decision really does is it puts a spotlight on Congress's ability to remove or eliminate the most tricky question that's presented on this to the court. So, you know, this novel question that I mentioned before about Congress's ability to put a time limit on this, and whether it can do it in the way that it did so here. Well, we wouldn't need to be talking about that here if Congress removes the deadline. So yesterday, the House passed a resolution to remove the time limit, and if the Senate also removes the time limit, then one would expect that the archivist will publish the amendment and people might stop suing him, but we'll see. I'll turn that over to Linda.
So we're going to turn now to answer some questions about what would the ERA do. And if you're interested in viewing the debates yesterday, you can find them online. It was a really interesting morning. It's the second time the House of Representatives has debated the time limit removal issue. They passed a resolution a year ago that would remove the time limit. They passed it again yesterday. It was a bipartisan vote, although it was quite close. And the similar measure is currently with the Senate Judiciary Committee and will hopefully move on to the Senate floor at some point in the not too distant future. The hearings yesterday were really interesting in talking about what the ERA would and wouldn't do. And one of the things I heard over and over again from the few people who spoke who were opponents of the ERA is that we don't really need it. Women, it's already clear that that men and women are equal under the law, and so the ERA won't really do anything. And so I want to start with that premise, which the late Justice Ginsburg spoke about pretty compellingly, which is, why isn't that a reason to put it in the Constitution as opposed to keeping it out? She said, even if the argument is that it is largely symbolic, it is a very important symbol. Why should the rest of the world have the equivalent of an equality guarantee and the United States does not? That's a reference to the fact that every constitution written since World War II in the world has included an equality guarantee, a ban on discrimination on the basis of sex. And most of the countries in the Western world have such an equality guarantee. The United States really stands out for its refusal to put a provision like that in the Constitution. So that's my answer to those who say, we don't need it. Well, the other answer is we do need it. For one thing, the 14th Amendment Equal Protection Clause has not been interpreted by the Supreme Court to provide the same level of scrutiny for discrimination on the basis of sex as it provides for discrimination on the basis of race. You may remember from con law class the concept of intermediate scrutiny, which was pretty much created for gender discrimination or sex discrimination. If you've seen any of the really wonderful documentaries or films about the late Ruth Bader Ginsburg, you'll know that this was really her life's work before she joined the court, and afterwards to some extent, which was to advocate for recognition of sex discrimination under the Equal Protection Clause of the 14th Amendment. And she succeeded, but only to a certain extent. The cases that she litigated yielded a holding from the court that subjects sex discrimination to intermediate scrutiny. And, you know, this is a complex issue, and I will tell you, for advocates, it's really challenging because nobody thinks that the difference between intermediate scrutiny and strict scrutiny is a selling point that lay people would be able to understand in terms of how why we need the ERA. But what we do know is that the ERA would elevate sex discrimination to a higher level of scrutiny than it currently has under the Constitution. And the other important thing about that is that justices who look to the original intent of provisions of the Constitution think that the 14th Amendment shouldn't provide any protection against discrimination on the basis of sex. Justice Scalia famously talked about that, concluding that when the 14th Amendment was adopted, people weren't thinking in terms of sex discrimination. And obviously that's true. When the 14th Amendment was adopted, women couldn't even vote. And we all agree we needed a constitutional amendment to bring the vote about in the early 20th century. So, the Equal Rights Amendment would provide something that the Constitution currently doesn't provide in that respect. And there's a lot of different ways in which that could be important. I'm going to turn it over to Kate to talk about that a little bit more.
Hi. This is so exciting, and I think you know, none of us have a magic ball. No, none of us have a predictive power of what the future will bring. And I think as lawyers, one thing we do know is that the Constitution is extremely important, and the provisions added to the Constitution are permanent. And so when I think about a lot of folks feel anxiety about, you know, how the ERA, let's say we got it tomorrow, you know, there is a very conservative majority on the US Supreme Court currently, and particularly advocates of women's rights are concerned that the amendment under the current composition of the court would be interpreted very narrowly, or even negatively, to take away, you know, in the way that some race-based protections have been used to eliminate affirmative action protections or other things, that it could be used by the men's rights movement to you know, take away rights that women already have. That's a scare tactic from the 70s that continues today. But I think it's important to remember that as a permanent amendment to the Constitution, the ERA will outlive everyone who currently is on the Supreme Court. The ERA will outlive everyone on this call today. The ERA will outlive anyone alive in America. It is a permanent amendment to the United States Constitution. It will be here in 100 years. It will be here in 200 years. And we don't know what the future will bring. What we're providing by enshrining the 28th Amendment, as we can start calling it, the 28th Amendment into the US Constitution, is a tool for future generations. And I think it's really exciting to see, for example, like Linda said, some younger folks being involved in the ERA movement for a long time. You know, I've been doing the ERA thing for about a decade. For a long time, I was the youngest person in the room, and I am 40, so I'm not that young. But it's going to be used for future generations and future things that we can't even conceptualize now. So it's going to be this very useful tool. When you think about amendment, like think about the Second Amendment, the way that is now being used is not something envisioned by the people who wrote it or even ratified it. And so I think, yeah, one of the exciting things about the ERA and its future interpretation is, one thing is pretty clear, that the language that we have, this language that was passed in the 1972 amendment and was changed from the 1923. So the 1923 language had the word men and women in it, had the words men and women in it, and that was changed in the 40s when it went from being the Lucretia Mott Amendment to being the Alice Paul Amendment. And the Alice Paul version of the amendment was passed in 1972. And that language, as we had seen, or as you can see, it just says on account of sex. Now, on account of sex is not the word woman and is not the word man. And there isn't one particular gender mentioned. This, as we know, opens us up to further protections for folks who may not have been originally envisioned in the 1923 or even in the 1940s. And so we have the Bostock decision, the recent Supreme Court case that has said that under Title VII, the language of on the basis of sex does include not only transgender people or prevents discrimination on the basis of gender identity, but also sexual orientation. And so both of those things are envisioned under the words on account of sex. And that, I think, is the main reason why equality advocates, folks, LGBTQ folks like me and others are particularly excited about the ERA, because in the judiciary hearing when Linda was there, and I think a lot of other folks were there in the judiciary hearing last year, all of the witnesses who testified in support of the Equal Rights Amendment, and keep in mind, this is the only modern hearing on the ERA on record. It was the first hearing on the ERA in Congress in 36 years, and there wasn't a hearing this year. So that hearing that we had last year was really the only modern elucidation of what the Equal Rights Amendment means to legislators who are passing the deadline elimination bill. And in that hearing, all three of the witnesses affirmatively testified multiple times, including the constitutional legal scholar, that the ERA is envisioned to cover trans people. That's an argument that is used to fight the Equal Rights Amendment and try to divide people and scare feminists and say, you can't have the ERA because then trans people are going to use it. But luckily, trans people have also been very involved in passing the Equal Rights Amendment, including state delegate in Virginia, Danica Roem, who was the floor whip for the ERA there, first out transgender legislator in any in the United States history. So trans people have also also Polly Murray, of course, pioneering legal theorist. So trans people have always been involved in the Equal Rights Amendment, and we know going forward will also be included. And that's not a thing to be afraid of. That's a thing, I think, to celebrate it, and a reason that we should really look forward to the ways that the ERA will be implemented.
Thank you, Kate. Thank you, Linda and Kathy. Also, what a fantastically fascinating and informative panel discussion. We have a couple of questions. The first one coming in is in the panel is a popular culture question, and then we do have a current events question. I'd like to read that question to you then, and then who'd ever like to field it. Sure. Do you think Mrs. America, which was a 9-episode, 1-season, it's on Hulu now, accurately depicts the struggle with the ERA in the 1970s? The questioner read that Gloria Steinem's op-ed said that the show is not accurate because it makes it seem the ERA failed based on fights between women, for example, Phyllis Schlafly, when actually insurance companies and other lobbyist groups are behind its failure in the 1970s. And the questioner would like to know your thoughts.
Kate, you want to take that?
There's so many thoughts about this. I think that the first thing to keep in mind is Phyllis Schlafly never voted against the Equal Rights Amendment. She ran for Congress twice, but she was never in a position of power. The people who voted against the Equal Rights Amendment in the original iteration were men, period. The people who organized against the Equal Rights Amendment were largely funded and run by men. So there were really, there was a lot of organization on the ground, and Phyllis Schlafly is a very key figure, and I think that was accurate. But to say like it was just women squabbling and that's why it didn't get passed is very inaccurate, and it is also inaccurate today. The Equal Rights Amendment has wide support for Americans today. I think it's 94% of people support gender equality in the Constitution. So yes, the original fight was organized. She organized women, that's true, to oppose the Equal Rights Amendment. And this is this is where you should listen to my acclaimed podcast, Ordinary Equality. I have a whole episode about the Long Southern Strategy. And so Phyllis Schlafly really was part of what's called the Long Southern Strategy to get to turn the South red. And in that strategy, she used anti-feminism, opposition to abortion, Christian nationalism, and racism. So all of these things were combined. It wasn't just racism. All of these things were combined, and they were part of a larger political strategy, and specifically anti-ERA opposition was part of that strategy. But who funded that movement? Who were the people who voted against the ERA in those state legislatures? That was not women. And so there was a cover of women as the political speakers or activists against it, but that is not the true and full story. I'll end by saying there was an equally famous woman at the time who was fighting for the Equal Rights Amendment. Her name is Sonia Johnson. And Sonia Johnson is a Mormon woman who really rose to prominence by combating Orrin Hatch on the Senate floor. So she had this big showdown where Orrin Hatch said that Mormon women opposed the Equal Rights Amendment, and she, this relatively unknown wife from Virginia, they kind of pushed her to the front. They're like, okay, tell him. And she said, no, there are Mormon women who support the ERA. And Sonia Johnson, I've come to know her. I was also raised Mormon, and I've come to know her since. And one of the things I found really interesting to me is she said in the 1970s, she was like on the cover of Time magazine. She was a presidential candidate. She was always speaking out on the ERA. And she said on programs, they would try to put me against a woman. So it would be a debate, and it would be pro ERA and anti ERA, and they always tried to make it women. And she said, I refused to debate or even have like a counterpoint discussion with women, because the people behind the anti ERA movement were not women. The people who benefited from keeping us out of the Constitution are not women. And so I'm not going to let them control the optics and make it seem like I'm against another woman. My fight is not with her.
And I have to say, I agree with everything Kate just said. I happen to really love the series, and I'm sure Kate watched it too. And you should watch it just for the clothes and the music, because both of them are fantastic. But one thing I think it did do with Phyllis Schlafly that I think, and you should also read the op-ed that Gloria Steinem wrote along with Eleanor Smeal about what about it isn't representative. I do actually think it was very telling the way the series portrayed Phyllis Schlafly as a working woman, and the sexism that she faced in her own home, et cetera. So as much as she her public persona was, I'm this housewife who's organizing people and literally planning bake sales, to like bring baked goods to members of the legislature. At the same time, she was a woman who was working outside the home, organizing large groups of people, and really trying to get a position in Congress or with the administration in Washington, D.C. And that's a whole side of Phyllis Schlafly that is not consistent with her public persona. So it's a very interesting to watch, like many.
And she was a lawyer.
And she was a lawyer. She went to law school, actually, and that's depicted in the show as well.
Yeah, I think that the other two panelists are more of the historians on this than I am. And I think it's right to always be skeptical about who's funding what. I would say that, if there's any indication for the broad support in the business community today, one example of that is just in our litigation. I mentioned that there was an amicus brief filed by over 100 businesses that ranged from Apple to the NFL to Lyft to Estee Lauder to Google. So it's not to say that there might not still be powerful corporate interests still against the ERA, but I don't think that big businesses are seeing the ERA as a threat to their way of doing business today.
That's a great point.
That's fantastic. Thank you all. We do have, I think we have just about 7 minutes left. If I can ask you one more question.
Sure.
Every day, we see that violence against women remains a serious issue, including recent spikes against women of color and trans women. What are some examples of ways that, when enacted, the ERA could address this violence?
Well, let me start with one affirmative thing, and I'm not sure I can reshare my screen, but let me try. And that is that if you look at the language of Section 2 of the ERA, it's the Congress shall have the power to enforce by appropriate legislation the provisions of this article. What that would do is it would provide another source of power for Congress to use to enact legislation that protects against discrimination in law enforcement, against discrimination in how the government treats orders of protection, protects women and gender minorities, sexual minorities, et cetera. And there's a concrete way in which this, in which I think I can highlight this. A couple of years ago, there's a statute, a federal statute that prohibits female genital mutilation and makes it a federal crime. And a federal judge in Michigan struck down that statute and held that it was in excess, it was Congress acting in excess of its powers under the Commerce Clause. And as we know today, pretty much everything Congress does is pursuant to its powers under the Commerce Clause. And sometimes the Congress just gets a little bit too far afield from Congress, and that's what from commerce, and that's what this judge said had happened with this statute. The second clause of the ERA would provide an alternative source of power for Congress to act in ways that protect sexual minorities, women, girls, etc., from violence, and that's one concrete way. Kate, do you have some other thoughts on that?
Yeah, I think we think a lot about Section 1 because it's so succinct, and we're lawyers, and so we're like, let's talk about scrutiny. Like Linda mentioned, is harder for other folks to understand, and also lawyers. Let's face it, who knows what scrutiny means? Nobody, or what it concretely means or will mean in the future. But another thing, the Section 2, I think, is the most important clause of the Equal Rights Amendment, in my opinion, because it will help, like Linda said, legislatures do different things, completely different things that they never could have had because there was no hook in the Constitution. You know, they're trying to, like, I call it shimmying. They're like trying to shimmy in protections for violence against women under the Commerce Clause, which was not intended for that. Another concrete example is the private remedy in Vawa, the Violence Against Women Act, which was just again voted on, the reauthorization was voted on by the House yesterday. But in a case called the Broncala case, of the private remedy, which was originally envisioned in the 90s when Joe Biden and other folks were passing Vawa, there was a private remedy, and that was struck down by the Supreme Court specifically. And so I think things like that, like actual accountability for violence. There's another famous case that rose beyond the Supreme Court and went all the way to the Inter-American Court, which is a regional system based in Washington, D.C. The court is based in San Jose, Costa Rica. And in that case, it was an enforcement of a protection order against a woman named Jessica Gonzalez. So I think there are some really concrete ways in which these private remedies or enforcement of protection of women are not available under our current constitutional regime that we can have in the future if we have the ERA.
Mm-hmm. And the ERA will also provide a tool for litigants to use against the federal government, against state governments, against municipalities for discrimination in terms of law enforcement, for example, and how orders of protection are enforced. You know, I think all of us are thinking about the victims of the shooting in Atlanta, a shooting that seems almost certainly motivated by both race and sex, and you know, to the extent that there is a reticence on the part of law enforcement to call it that or proceed on that basis, you know, the ERA is a tool. And what would that look like in a particular lawsuit? It's hard to say. You would need to, of course, it's hard to bring a lawsuit like that. You need to satisfy lots of requirements. But at a minimum, this would be a kind of a statement of a national norm, a provision that is that is reflected in our foundational document that can be the basis of conversations about whether a particular movement by law enforcement is sufficiently respectful of sex, and it would give just another way to talk about it and another tool in litigation.
Well, thank you. Thank you so much. I know Lisa put the code in the chat box. The CLE code is 31821. I'll just double check and be sure that we don't have any other questions that came out while you were providing those amazing answers to the other questions. Do you have time for one more question? What are the social reasons opponents cite for their opposition today?
The Equal Rights Amendment, many of the opposition arguments in the 1970s are now moot, and hopefully mute. But they include military participation for women. You know, they would like go to these protests in like fatigues and dump themselves in red blood and say they're going to drag women out of their homes into the front lines of war. All of those original arguments are pretty much moot, except for the ones that I hear most often are abortion access, trans rights, and some arguments to a lesser extent about Social Security benefits and something like, I would say, family law concerns. But those are the main ones I hear. And honestly, the opposition to the Equal Rights Amendment comes to hearings and just basically shouts abortion, 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 abortion. And we can, if we had more time, I could talk extensively about why that argument is invalid. I have 10 hours of podcasts that you can listen to, but in the short term, I will say that the Representative Nadler said it best last year on the floor. He said, if people on the other side want to admit that equality of rights under the law means there must be a constitutional right to abortion, that's wonderful. The constitutional right to abortion already exists. We have it nationwide in every state. It is a constitutional right to be able to access abortion care already. And if people want to admit that an equality provision in the Constitution would protect that, great, that's wonderful.
The military argument is one that still occasionally comes up, and the idea that the all-male draft would have to be, we would have to get rid of the all-male draft. And I guess my thought, first of all, there's already a judge in Texas who held that the all-male draft violates the Equal Protection Clause. And that issue is being briefed in the Supreme Court right now on petitions for certiorari. We'll have to see if the court takes the case. But there's nothing prohibiting the Pentagon right now from beginning, in the Congress, from requiring women to register for the Selective Service. So, and in fact, that's something the Pentagon has recommended we do. John McCain advocated for that before his death. And, you know, my personal interest is more in protecting the rights of women who have volunteered to serve in our military and are fighting with great distinction in every aspect of the military service. I'm more interested in protecting their rights than in perpetuating an all-male draft, which it would seem completely inconceivable that if we had a draft right now, only men need to go. It just seems like a very bizarre concept in 2021. So, but as Kate said, many of the other arguments are just moot at this point.
Well, thank you all. Thank you so much for this sparkling and fascinating presentation on the ERA today. What a treat it was. And on behalf of the Chicago chapter of the FBA, I want to extend my gratitude to all three of you for your generosity of your expertise and sharing all of this with us. Thank you very much. And thank you to the attendees. We also appreciate your support. Thank you. Have a great day. Thank you. Bye-bye.